Welcome back to Out of the Rough. I'm Fred Arnold. I'm joined by Jeffrey Fuchsman. Jeffrey Fuchsman is a fellow provisor, a network group we belong to help each other build our businesses. And you're a partner in the labor and employment law of Ballard, Rosenberg, Golper, and Savitt. Did I get that right?
You did.
Very good. And of course, it should say, and Fuchsman.
Someday.
Yeah, welcome to the show. Welcome to the show. We're going to talk about employment law. And employment law is really important to talk about because it really changes with different administrations, both on the state side and the federal side, different rules that come out all the time. You know, why is this so important to take a look at with every business, big or small?
Well, you know, Fred, you made a good point. Employment law compliance is a very challenging area for employers because, number one, you've got the state and federal legislators that are passing new laws every year that impact the employment relationship.
You know, that's true, right? They're legislators, so they have to legislate. They're not unlegislators, they're legislators.
Exactly. If they weren't passing laws, they would be out of a job.
I guess they would, right?
And in addition to that, we have court cases that are coming out literally every day that are providing more nuances and sometimes changing in subtle and not so subtle ways how these laws are being enforced. And then the governmental agencies that regulate employment, and there are many of them on the state and federal side, the heads of these agencies are generally political appointees, and when new administrations come in, the enforcement position of these governmental agencies change, sometimes to be more employer-friendly and oftentimes not. And so it's a very challenging environment for employers to stay ahead of the curve and stay in compliance.
Yeah, you know, as an employer of quite a few employees myself and as the chairman of the Chamber of Commerce, I don't know of any business individual owner that doesn't want to do the right thing for their employees because it's the right thing for their business. But there are some potential areas of exposure if you don't know, you don't know. What are those?
You know, Fred, in my experience, I agree with you 100%. Employers are trying to do the right thing. But, you know, this area is very technical, and as I said, it's changing, and so a lot of employers just don't know. One of the areas that we've seen in our practice that it's easy to make a mistake is in the area of wage and hour compliance, because there are so many requirements that employers have to be mindful of, whether it's overtime exemptions, whether it's calculating overtime the correct way, whether it's providing your employees with meal breaks and rest breaks, record keeping, vacation accrual. There's just so many areas for a well-meaning employer to make a mistake, and these mistakes could be very costly because, you know, it used to be that these claims would be brought by a single employee in front of the labor commissioner. If you made a mistake, it might cost you a couple of $100.
And you fix the mistake.
And you fix the mistake. Now, these cases result in class action lawsuits. Right. Every day in Los Angeles County, there are several wage and hour class actions being filed against employers that could cost millions of dollars.
And you bring up some important points, salary versus hourly, overtime. I mean, there's so many different nuances. I want to bring one last thing up, and that's something on meal breaks. Sometimes employees don't want to take a long lunch.
Well, you're right, Fred, and you know, the whole issue of meal breaks was sort of a hot topic for people that do what I do for a number of years because it was an important case that was pending before our Supreme Court involving the Brinker restaurant chain, and a lot of companies were anxiously awaiting for the court to render a decision, and they did last year. And so it added some clarity to the law, but I think a lot of employers are looking at that decision and with the wrong takeaway. The issue that employers were facing is whether they have to be meal break police and force their employees to take meal breaks as opposed to just make them available. Well, the Supreme Court clarified that and said all employers have to do is make them available. But that still, you know, requires vigilance on employers' part to make sure that the working environment is such that employees can take meal breaks and that they document when they do. And
you're talking about preventing challenges and preventing problems, which is the next thing I want to talk about. You mentioned 4 things off the top that you think were critical to prevent challenges with this and make sure you're treating employees properly.
Well, one thing to do is to do a full compliance audit before you have a claim. And, you know, have either a lawyer or your HR professional come in and review your practices to make sure that you're in compliance. Management training is very important. Some training is legally mandated. If you have more than 50 employees, then you are required to provide supervisory training on sex harassment every 2 years. So training is extremely important. Employee handbooks is another area that employers should be
and sometimes
looking at.
review the handbook with the employees.
Right, absolutely.
Yeah, that would be a spot. Don't just give it to them, but review it.
Absolutely.
Yeah.
And you know, insurance, a lot of these risks are insurable now under employment practices liability insurance. Even in the wage and hour area, some insurance companies are writing policies that would at least provide you with legal defense should a claim be filed.
Yeah, boy, our time is almost up, but in about 30 seconds, really quickly, what are some of the hot issues?
Well, you know, we talked a lot about wage and hour, and there are some, you know, changes going on in the types of claims that we're seeing. But another area that I wanted to mention that we see a lot of activity on has to do with employees with disabilities, employees that can't work. And it's the one area that employers have an affirmative duty to accommodate employees with disabilities. And so, you know, whenever there's a situation that comes up, you know, my advice is pick up the phone, call your lawyer, call your HR advisor when you're dealing with employees with disabilities, and make sure that you're handling the situation appropriately.
Yeah, an ounce of prevention prevents, what is the word? Something like that. An ounce of prevention saves a pound of trouble, or something like that.
Well, you know, we joke with our clients. We say we're like the Midas, you know, pay me now or pay me later. So. Okay.
Good stuff. Jeffrey, how can those that want to reach out to you get a hold of you?
Well, they can reach me on our website, which is www.brgslaw.com. My email would be letter J, Fuchsman @brgslaw.com. Or they could call my office, which is 818-508-3700.
Thanks for coming in. Thanks for sharing with us.
Thank you, Fred.
Absolutely. Ladies and gentlemen, Jeffrey Fuchsman talking a little bit about labor and employment law. We're going to jump to a quick break, and we'll be right back.